Well, there are two basic groups when you talk about the restriction of trade under the Florida statutes and under the case law that exists in the state of Florida. The first is where you have non-competes between an employer and an employee. And the second group is restrictions such as trademarks or intellectual secrets, those types of things. So you work for a company and so you have to make sure that your intellectual property doesn't get distributed to other companies via a prior or former employee. In the case of the non-compete, you're dealing with an employer-employee relationship, and basically what you're saying is that as the employer is taking the time and the money and the effort to train the employee and to give resources to keep the employee trained. And in that particular instance, the employer has a right to protect the employee from learning all of that business, and also too having a connection, that business connection that he or she would not have had if not for the employer. And so take, for example, an HOA or a condo. So you typically have a property management company, and the property management company will put an agent that will manage the property. And so the agent works for the property management company, and all of a sudden the association goes to the particular agent that's running the association and says, well, you know, I pay this property management company a lot of money. Why don't I just hire you myself, or you can go to work for a cheaper property management company. Well, the property management company is the one that made the deal with the association in the first place. The agent never would have been there without the property management company. So the property management company has an interest in protecting that. So what a non-compete does is it limits by duration and by geographical scope, and also by the scope of the type of work involved. But it based upon that, it limits the employee from going and doing work that would be in competition with their former employer. So whether or not they do that on their own, or whether or not they go to work for another company that does the same kind of work, then the employer, if they have a non-compete, can enforce that and get an injunction against him or her. They can also to have the possibility of getting monetary damages, whether those are liquidated damages in the non-compete contract, or if they're actual compensatory damages that the employer can prove. And then also too, the company that hires somebody with a non-compete has exposure from what's called tortious interference with the contract, because there's a contractual relationship keeping that employee from working in the same kind of industry for another employer that does the same kind of work. And so if they hire someone knowing they have the non-compete, then they also too have some exposure to a possible lawsuit and possible damages based on a non-compete.